President, please be seated. The court is now in session. The floor is now given to the Deputy Co-Prosecutor to resume the questioning. But please wait. You may proceed first, Counsel Ang Tak Bise.
Thank you, Mr. President. I simply like to make or to express a request on part of our team. Could we remind the witness to speak a bit more slowly, because in French we have a real problem following the flow. And when we deal with topics that are a bit more complex, and when we deal with terms that are particular to the CPK, it's important for us to have an accurate translation on time. So it's just a simple request I'm making here.
President, very well. The witness, I hope, is understood the request made by the counsel of the defense team. So please speak slower. It's very important that you speak slower so that we could have proper record and for the interest of the proceedings. You may proceed now, counsel.
Thank you, Mr. President. Good afternoon, Mr. Witness. Last week we were talking about interrogations and confessions, and I had a couple more questions, follow-up I wanted to cover on that subject. And Mr. President, can I return to the witness the binder of the interrogator notebooks, as I have a question from one of these documents?
President, yes, you may proceed.
Mr. Witness, I'm handing you back the binder, and the specific excerpt I want to ask you about comes from the statistics list interrogator notebook, document E3/8368, Khmer, pages 0000 7470 through 7470 through 71, English 00225 395, French 00278 759 through 760. And this is in the section 4 titled Views and Stances on Enemy Confessions. Paragraph 2, I've marked it in your book, reads as follows, contains the following statement, quote, "We only ask the points that the party instructs us to ask because the party grasps the situation." End of quote. You've indicated that these are notes from instructions you gave to the interrogators. What was meant by the statement that we only ask the points that the party instructs us to ask?
I have not found the right statement you quoted. Which paragraphs and which number you are referring to?
It's marked with the letter A on the post-it. Yes. If you look at the bottom of that page, if you read paragraph 2, you'll see a reference in there to this. We only ask the points that the party instructs us to ask. Do you see that in the notes? What was meant by that?
Thank you. Before responding to your question, I would like to make a clarification. These documents belong to the interrogators, and the note was about the methods of interrogation. The owner of this notebook is Pu Pali. Concerning the issue that you raised as the points that the party instructs us to ask, I told the court the last days already that first we permitted the prisoners to respond and to tell whatever they wanted, and then we would determine the advantages and weak point, the strength and weak points of the prisoners. And the point that the party was instructed us to ask is the point in relation to the enemy network and also the CIA or KGB agents. And I don't think that the interrogators would include the points of my instruction, all of them. And once again, the interrogators should not allow the prisoner to know what the interrogators want to obtain. Interrogators should be avoided, that the prisoners knew what they wanted. For example, in the case of Jum Sambat, the interrogator was trying to avoid the fact that not to allow Jum Sambat knew that the interrogator wanted to get the implication about Chan Chakrai.
Well, let me give a few examples that I found in the interrogation records on this issue of what was presented or what was told to prisoners during interrogations. Mr. President, if I may provide to the witness a document E3/8374, E3/8374. It's a 25 September 1976 note or letter from Pon to the witness.
President, yes, please.
First question, do you recognize this as a note that was written by interrogator Pon?
Thank you. This writing belongs to Pon. This letter indicated the methods I instructed Pons to interrogate Bong Ya. That is the letter pretended that we fabricated.
Let me read, Mr. Witness. I want you to focus. The first paragraph talks about the use of torture that had been instructed by Ankar. It's the second paragraph I'd like to focus on, and it states, the essence of propaganda based on the instructions. And then point A, well, first of all, A is a letter that was from you dated 24th that I believe was supposed to be shown to Ya. But it's the next 2 points that I want to ask you about, because Pon writes, I quote, "We quoted the confession of Chu Bun Lit from 703 and Mam Visal from 107 to show him." And then the next point, propagated from the confession of 8. 8 was a number or pseudonym that was being used, had been used in relation to Chuk. Propagated from the confession of 8, and then it states, the assignment of a new party with Khao Mia and Brother Chuk acting as central organization committee. My first question, what did it mean to say that the interrogator propagated from the confession of 8?
Co-prosecutor is reading a different and more detailed document, I believe, and this is the letter which is associated to Pon. I made the report of the names to Son Sen, particularly in relation to the confession of Chu Meng Liet 703 and Mom Bisal 107 to show him. In fact, I was permitted by Sun Sen, and in terms of interrogation, on some occasion I needed to have permission from the upper echelon. And I told the court already that I had telephone communication every evening with Sun Sen. C, propagated from the confession of number 8. I do not know who number 8 is. I do not recall the person by the name number 8. The assignment of a new party with Khao Mia and Brother Chuk. That party was a new party, not the party that was created in the 1960s. The party here, I guess, refers to the party that was in existence long time ago. That was before 20 July 1954 rather. And Mr. Co-Prosecutor, you may have recalled about the date 20th July 1954. Chuk and Mies were part of the standing committee of that party, and Ya was also an important individual within the party. And the other point is the secret contact with Vietnam when Mirza within in Phnom Penh. So the purpose was to encourage Ya to talk about the conversation with Bong Mia.
Mr. Witness, did the information about this new party, the information about the contacts with Vietnam, is this information that had come from the confessions of previous people who had been interrogated, such as the people who are identified in this document?
That happened a long time ago. However, after my reading of this document, these were quoted from those individuals, Bun Liet, Chuk, and Mom Visa. So the statements of the three individuals were combined together and put in this document, so that the information can be used as the measures to interrogate. The main purpose of the interrogation was to find out the contact with Yuan.
Thank you, Mr. Witness. Mr. President, next I'd like to present another document. This is a report from an interrogator, a report dated 22 July 1977. Document E3/1705. E3/1705. May I present it to the witness, Mr. President?
President, yes, you may.
What I've handed to the witness are Khmer ERN pages 000, 140, 91 through 96. Again, this is from E3/1705. The corresponding English page 00183, 285 through 290. And French 00373, 117 through 120. This is a report from an interrogator on the interrogation of the former Sector 7 Secretary K. Kim Hood. And if towards the end where I've put the post-its, Mr. Witness, the parts I wanted to ask you about, first of all, Section 4, Paragraph 1 reports as follows, quote, "On the morning of 18 July 1977, we decided to do torture. We told him the names of those who had implicated him." End of quote. And then if you look on the next page of the Khmer, in Section 5 of the report, the interrogator specifies further as follows, quote, "I told him that those who had implicated him were 1, Su said he was CIA, 2, Mai said he was CIA, 3, Tiv Ol said he was CIA, 4, Yi Yon said he was CIA, and 5, Dim Saroon, alias Men, also said he was CIA. End of quote. My first question, how did the interrogator know the names of the people who had implicated K. Kim Hood?
What is the name of the concerned interrogator? I presume that his name was Comrade Ha. How could he got the information? Ha was one interrogator among others, and he was assigned to conduct the interrogation. So the information in the confession was owned by the group of interrogators, so they may have known who implicated whom.
And do you understand what was the purpose of telling the prisoner that was being interrogated who had implicated him? What was the purpose for doing that?
Thank you. Brother Kumhut alias Sot was a stubborn person, and he did not confess easily. So when we had no way out, and after we had the permission, we showed the implication to him. In fact, these measures were not so good, so we use this kind of measures only when we had no way out.
Thank you, Mr. Witness. Next, Mr. President, I'd like to present to the witness an excerpt from document E3/1891. E3/1891. This relates to the interrogation of Division 310 Secretary Un.
President, yes, please.
For the record, the specific pages I'm going to ask the witness about are a statement, and this is the first or second day, the arrival of Division 310 Secretary, a document dated 20 February 1977, English ERN 0096819 through 20, and Khmer 0001791 through 03. Again, E3/1891. No French translation at this time. I've marked the pages for you, Mr. Witness. The statement I wanted to ask you about reads as follows. And this is from Division Secretary Un. He wrote, "I am supposed to report about my plans for a coup d'etat against the party, which I respect as much as I respect my own life. I have nothing to hide from the party. I have had no thoughts of carrying out a coup d'etat against the party. I find this question preposterous because the thought has never even occurred to me." And here's the specific point I want to ask you about, Mr. Witness. Quote, "Another thing..."
President, please hold on. You may proceed now, Counsel Ang Tak Wise.
Well, here I'm objecting in principle. It appeared to me that the Chamber's decision was that we're not supposed to read the content of confessions. But this is what the co-prosecutor is doing right now, so I object to this line of questioning, or in any case, the way the questions are being phrased, because he's reading straight from a confession.
Your Honor, this is in fact, the exact opposite of a confession. This is the very first statement from this prisoner, and he is adamantly denying that he is involved in anything. So this is not something that could possibly be barred by the Torture Convention. This is not a confession. This is the prisoner saying, "I did nothing wrong," and the relevance of this is to show the procedure here. He makes specific reference to what he was being shown by the interrogators. So this is not, the Torture Convention bars statements obtained by torture. It does not bar admission of a prisoner saying, "Why are you arresting me? Why are you torturing me? I've done nothing wrong."
Well, here again I have an issue in principle. I believe that we spent a lot of time speaking about how the interrogations would take place at S21 and how different methods were used, as the different witnesses explained here before us. Here, what the co-prosecutor is telling us is that since what transpires from this confession is something that he feels is useful for his case, he can use it. Whereas if we stick to what was said until now by the different witnesses, as of the moment that someone is interrogated, whether it's the cold method, whether it's the hot method, as soon as someone is being interrogated, either there's torture or duress. You said this in different decisions that you issued for different witnesses. Here, the only difference, of course, is that the co-prosecutor believes that the content supports his case. Here, I object, and I stand by my objection.
President, you may proceed now, Judge Galvania.
Yes, a question for the co-prosecutor. So do you intend to use the content of these confessions, or do you intend to use annotations? And do you intend to read out the content to give meaning to the annotations? I'm a bit unclear about this, because statements made by prisoners at S21 imply a presumption. The chamber said so. The presumption being that there was a real risk of torture, a risk that these statements were obtained under torture. So can you explain to us what the purpose is of this reading that you are proposing?
Your Honor, we are relying here on the rule of the Torture Convention. We're not relying on this, as counsel says, because it helps us. The rule of the Torture Convention is that what is precluded are statements obtained by torture. Yes, there is a presumption because of the circumstances there that statements obtained were under duress. But we have, in this situation, and we see this sometimes, that there were some prisoners who at the outset of their detention, and there were prisoners who, despite the use of torture, said, "I am innocent. I did not do these things you accuse me of." How could that possibly be a statement obtained by torture? It is the exact opposite of a statement obtained by torture. It is a prisoner saying, "You can torture me, but I am innocent." And the significance of this is not so much the statement, the truth of the statement of this detainee, it's what he says about what the interrogators were doing, which is that they were reading to him excerpts from the confession of Khoi Tun to try to get him to confess. And he is saying here, there is no truth to any of this. So our position, so it's very clear, this cannot be a statement that is barred by the Torture Convention.
Can I just ask a clarification as to exactly what your argument is? Is your argument, yes, I'm confronting him with the contents of a statement made under torture, but because he says it wasn't me, so it's not technically confession, it's not covered? Or is your argument this cannot possibly have made a statement under torture because he said I'm innocent? So which argument is it? Is it an argument which goes to we can use some of the contents of a decision, of a statement even if it was made under torture? Or is the argument the presumption that S-21 statements were made under torture doesn't apply here? So which is the argument?
Thank you for letting me clarifying that. It's more the latter, because we've already used. Let me remind you, and admitted a number of these in the past, where we've had a few particularly high-profile prisoners who, at the very outset of their detention, wrote letters or statements saying, often addressed to the party leaders, saying, "What are you doing? Why are you arresting me? I haven't done anything." We've used that initial statement from Hunim, also from, I think, a secretary of Sector 103 or 106, Bufat. And this is the same thing. This is a statement from this prisoner when he first arrived at S-21, maintaining his innocence. So our position is that cannot be a statement precluded by the Torture Convention, because it is an assertion of innocence by the witness. By the prisoner. The prisoner is doing the opposite, the very opposite, and defying what the interrogators wish him to do, and asserting his innocence.
But this is mixing arguments again. Is the primary argument the presumption that S-21 statements were made under torture is rebutted here? Because if he says, I didn't do it, he obviously didn't do that under torture. Is this the basic argument?
In a word, yes.
Yes, Defense Counsel, you had the floor.
Excusez-moi.
Court's indulgence. Sorry to interrupt you. Before you go into deliberations, bearing in mind the clarifications of the co-prosecutor, the question arises as to the basis on which the co-prosecutor says that this document is different from other S-21 documents, whereas we have had before this chamber witnesses who explained the process of interrogating the prisoners. They had to talk about the identity of the persons interrogated and the contents of their statement. What is the basis for this presumption? I do not see any reasons why we should consider that this document should be admissible.
Any further comments from any of the other counsel?
Other than that, I'm very curious how you're going to deal with this in the light of your decision not that we cannot use Khoi-Toon's confession.
President, the Chamber rules that the objection by the Defense Counsel accused some point to the question by the Deputy Co-Prosecutor with an excerpt of a statement presumably obtained under torture, and that or any document arriving from ISN1 is a result of torture, and the Chamber holds that that objection is sustained. For that reason, Deputy Co-Prosecutor, you are reminded not to use excerpts of the statements to put question to this witness or through any other upcoming witness before this chamber. Upcoming witnesses before this chamber.
Thank you, Mr. President. Let me move to my next document and next subject. I want to return briefly, Mr. Witness, to the issue of prisoners who were sent from Praesar to S21 for execution. And, Your Honors, I'd like to present to the witness document E3/1041, E3/1041, which is a report from Hui, from Office 24, dated the 24th of March, 1977. With your leave.
Yes, you may proceed.
And if we may display this on the screen. Mr. Witness, document E3/1041, dated the 24th of March, 1977, is a report signed by Hui. In the chart, it lists 5 people who have infectious diseases. And the first thing I want to refer you to is the handwriting that appears at the bottom of the document. This is, and let me read, the handwriting that I'm interested in states the following. The number of people requested to send to 21 includes, and then there are 4 items listed, people who have infectious diseases, 5 people. Those who acted against revolution, 4 people. People who were seriously incapacitated, moved freely, were lascivious, 15 people. And then people who were pregnant, 13 people, for a total of 37 to be sent to S21. First question, do you recognize the handwriting of this note that appears at the bottom of this document? Whose handwriting is that?
He made a report to me with his handwriting, but it happened a long time ago, so it is very difficult for me to identify his handwriting. Here we see his signature. However, this document should be part of S21 work, and that a number of 37 people were sent from the rice fields to Phnom Penh. However, they were not supposed to be. They were supposed to send from Praesar to June 8.
And can you explain why is it that, let's start with the 5 people who had diseases. What was the reason that people with diseases were being sent from Presar to Chung Ek to S21 for execution?
The 5 prisoners had infectious disease, that is sexually transmitted disease and TB.
And so what was the reason for killing these people, Mr. Witness?
The first reason is that they could infect other inmates. Second, we did not have medicinal treatment for sexually transmitted diseases and tuberculosis.
Your Honors, and for the record, there are 9 specific names of people in this report. The first 5, the people with the diseases, and then the next 4, who are also identified below them. Each of them appears on the OCIJ S21 list as having been executed on the 25th of March 1977, the day after this report. For the record, you will find those the reference numbers in the OCIJ list for these 9 people are number 3259, number 3306, number 3289, number 3272, number 4422, number 3248, number 3270, number 2119, and number 3292. There's a reference in the note at the bottom to 15 people who were seriously incapacitated, moved freely, or were lascivious. What was meant by that? Who were these people, and what had they done to deserve to be sent to S21 or Chung Ek for execution?
This is the first time that I see this document, and of course I made my comment regarding the first part of the document based on my knowledge. And to respond to your second question, you spoke about people who were seriously ill, who could not walk, or rather who were seriously incapacitated, move freely, or were lascivious. I believe the solution to these problems was the principle that we implemented last week, that is, to keep is no gain, to lose means no loss, or to remove means no loss.
Thank you, Mr. Witness. Mr. President, next I would like to present to the witness the document E3/10506, E3/10506, and E3/8657. E3/8657. These are two lists, prisoner lists from S21.
Yes, you may proceed.
Now, let me specify for the record the information from these lists on which I focus, and if we could display on the screen as well. The first list, E3/8657. These are documents that are just in Khmer. The Khmer ERN is 00230. 070 through 71. This is a list of prisoners who entered in March 1977 in the section for S21D, S21 Co. And there are 6 elderly women who were transferred from Praisar to S21 who appear in this list. They are numbers 799 through 803 and 806 on the list, if we can show that on the screen. Your Honors, Mr. Witness, the 6 women who were being transferred on the 25th of March 1977 from Praisar to S21 were a 75-year-old Sok Nai, a 74-year-old Ur Tuch, 73-year-old Tut alias Tun, 70-year-old Yus Pol, an 82-year-old woman, Niang M, and another woman, Ur Dame, who is listed as 92 years old. The second list I gave you, Mr. Witness, which is E3/10506 at Khmer page 01019379, records the execution of these 6 women on the day of their transfer to S21. They appear as numbers 102 through 106 and 109 on that page, if we can display that on the screen. And my question to you, again, Mr. Kanguki, why were these very elderly women being transferred from Praisar to S21?
First, allow me to make my impression on these 2 lists. Can you tell me whether these lists were extracted from the list of prisoners at S21 that were used to question to me, or these 2 are a separate list?
These are S21 records. I believe they've been discovered and put into evidence through a new list done by OCIJ, but so they are probably not documents that you have been examined on before. Do you recognize these as the format of S21 prisoner lists?
if these two documents extracted from the prisoner's list at S21 that were used to question me, and that was used to put a verdict to send me to life imprisonment, were not these two documents, as the sequential number of the list was different, and it was in Latin numbers. And now I am presented with a new list, and it is rather strange to me, so I do not know how to respond to your question. And I actually need time to read these documents fully before I can respond to your question. President, Mr. Kang Gai-il, as you have been informed a number of days ago, in fact, there's a new updated list of prisoners at S21, besides the list that was used for your case 001, and with the judgment that you were sent to life imprisonment. At that time, the list included about 11,890 names. However, with new investigations in other cases, namely cases 03 and 04, the Office of the Co-Investigating Judges made an updated list of prisoners, including the names of about 15,000. And the increased number was the result of findings of new documents that were used to compile the new list. So these two documents are the new documents that were not used to confront you in case 001. And the new list has a new figure, and it modified from the previous list of around 11,000 to 15,000. And that is the latest development in relation to the list of prisoners. And the new list has been part of the case file at present, and that parties can be used, the list, to question you. Of course, it is appropriate for you to review the list fully, so that you are in a position to provide precise answer to the questions put to you by the parties. So this is just to explain to you about the development of the list. And Deputy Co-Prosecutor, you have the floor.
Thank you, Mr. President. Mr. Witness.
Deputy Co-Prosecutor, please hold on. We noticed that witness Deutsche wants to speak. Please hold on and wait for the microphone to be operational. Witness, Mr. President, I'd like to put question to the chamber in relation to list of names of those who died at S21. The old list was included about 12,000 names, and later on, after I was tried, several names were added to the list, and they were still in the computer. And from what I heard, that those names of around 12,000 were sculptured or inscribed at Tuol Sleng with the fund from a German government. I recall that recently there was John Kerry, the Secretary of Defense, visited Tuol Sleng before he went to pay his courtesy calls to Hun Sen or Hao Nam Hong or the opposition party. And to my knowledge, I think both national and international community acknowledge those 12,000 plus names inscribed at the tourist line. This is my comment that I'd like to make, and the second part of my comment is that it is strange that I was confronted with these new lists, that list of people who were elderly, who were sick, and that they were sent to I-21. And if I am capable to make my full response, I would seek your permission to review the documents, the list first.
សូមជួយតាមវិញ្ញារងអន្តរជាតិគួរក៏
Deputy Co-Prosecutor, maybe you should try to use another line of questions to put questions to the witness. And if you want to use this line of question relying on the new list, it is better to give the list first to the witness so that he have time to review them before he can respond. Otherwise, there would be interruption during the proceedings since he would need time to review those lists. And Judge for defense, you have the floor.
I want to say something very general, witness. This is a separate trial. Your trial was a separate trial. This is a separate trial. So whatever a prosecutor or anybody else said in the first case, and you have frequently referred to the national prosecutor, is of very limited importance in this case. Second, yes, there is additional evidence that you are not familiar yet. We don't know yet where this evidence will go, but we have to deal with it. So it doesn't really help if you tell us any time you haven't seen a document in your own case that you don't like it because it wasn't presented to you in your own case. I would invite you to comment on the documents as far as you can. But as I said, these are two different proceedings. Is this clear?
Yes, witness Dutch, you can speak. Witness. I am satisfied with the explanation by Judge France. I would require to have a list, that is the old list of around 12,000 people before me, so that I can actually compare the old list to the new list. Of course, we had the proceedings in case 001, and if you refer to the previous documents, I am familiar with them and I can respond rather quickly. But with the new list, I need time to review it. And if I have the old list with me here too, I can do a cross-reference. I appreciate it if I can be provided with the old list. And Councillor Copper, you have the floor, says the President.
Yes, thank you. Mr. President, I would like to react to what the witness is saying. We would strenuously object the witness being provided either the old OCP list of 12,000 plus prisoners or the new list provided or made by the investigators of the international co-investigating judge. He is, as he said himself, the chairman of S21. He should be able to give evidence on the documents, the original contemporaneous documents that are shown to him, for him to be construing evidence on the basis of an Excel sheet either drafted by the prosecution or the OCIJ would be unacceptable. If that's going to happen, we again will have an unacceptable mix of his own evidence together with the products of the investigation. So we really object to the Chamber handing him either the old list or the new list.
Your Honors, I don't think anyone is proposing to do that, to hand him either the list of 12,000 or 15,000. We're asking him to review some original records. That's all. So I think the record should be clear that nobody's suggesting that he be asked to review the 15,000 or 12,000 lists.
Can I just put something on record? I'm not sure I remember it correctly. You're very stuck on this old list. This became obvious. Is it true that you were actually involved in compiling this list during the investigation, the old list? Or does my memory trick me?
Witness, thank you. I brought a copy of the combined list with me. It was at Takmau at the present time. It is now at Takmau. That list was given to me during the investigation stage, and the day after I was interrogated about the list that I was had been given the previous day. However, Vaughan's name was missing, but later on I found his name, and Kylie Kumhut was missing as well, but in fact the name was not correctly spelled in the list. The same applies to Von Wade, and the list was sent back to the co-prosecutors for revision. The list was revised twice before it became final, and the final version of the document is heading is list of prisoners at 21, the latest version. Revised version. That is the list that I have read before. And during the time that I was adjudicated by the Supreme Court chamber, I also reviewed that list. That list was drawn up based on our consultation during the proceedings at the time, and Wang Song was familiar with the list, I believe. And the list, I got the copy of it at the Kamau.
About to ask this, I think he had basically the whole case file in his cell, so you still have the list at your disposal. That makes the whole debate kind of moot. Is that true? You still have the old list in your cell?
That is correct. I got that list with me at the Kamau cell together with the binder of what I stated during the proceedings. But right now, those documents are kept at the cell, not with me here.
I understand. I think that clarifies that issue. Go ahead.
President, thank you very much. I think the issue has been dealt with. And it is now appropriate time for the short break. The chamber will take a short break from now until 3 p.m. Court officer, please assist the witness in the waiting room during the break time, and please invite him back into the courtroom at 3 p.m. The court